A pregnant woman walks into her doctor's office in Tennessee for prenatal care. She's expecting her first child. She's nervous but excited. She needs medical care to ensure a healthy pregnancy, and her doctor refuses to treat her. Not because she's high risk, not because she has complications the doctor isn't qualified to handle, but because she's not married. The doctor cites the Tennessee Medical Ethics Defense Act, a law that passed quietly in April 2025 that allows healthcare providers to refuse services based on personal, moral, or religious beliefs. The woman is left without prenatal care, forced to find another doctor, or traveled out of state, all because her marital status offends her physician's moral sensibilities. This is absurd. This is wrong. And this needs to be fixed immediately. You guys know I'm a conservative. I believe in religious freedom. I believe in conscious rights. I believe that the government shouldn't force people to violate their deeply held beliefs. But I also believe that when you become a doctor, when you take the Hippocratic Oath, when you accept the responsibility of providing medical care, you have obligations that supersede your personal preferences. The Tennessee Medical Ethics Defense Act, or MEDA as it's being called, is a bad law. It was passed with good intentions, trying to protect healthcare workers from being forced to participate in procedures that they find morally objectionable. But what it's created is a system where doctors can deny basic medical care to patients based on judgments about those patients' personal lives. A pregnant woman needs prenatal care, regardless of her marital status, whether she's married, unmarried, in a relationship, single. That's none of the doctor's business. The doctor's job is to provide medical care. The doctor's job is to ensure the health of the mother and the unborn child. The doctor's job is to not pass moral judgment and withhold care based on that judgment. And here's what makes this even more disturbing. This law applies outside of the emergency situations, which means that in non-emergency circumstances, a doctor can look at a patient who needs care and say no based on their personal beliefs. A rape victim who becomes pregnant and needs prenatal care could be denied. An unmarried woman could be denied. Anyone whose circumstances don't align with the doctor's moral views could be denied. This is not religious freedom. This is discrimination disguised as conscious protection. This is allowing personal judgment to override medical responsibility. This is giving doctors license to play God instead of playing doctor. Today, we're going to examine exactly what this law says, how it's being used, why it's wrong from both a medical ethics and a conservative principle standpoint, and what needs to happen to fix it, because conservatives should be leading the charge against this law, not defending it. This is government enabling discrimination, and conservatives should oppose that, regardless of who's being discriminated against.
Courage, compassion, faith, freedom, truth. Welcome to Courage in the Darkness with your host, Philip Roberts. It's time to awaken America.
Let's break down what the Tennessee Medical Ethics Defense Act actually does, because understanding the law is essential to understanding why it's so problematic. The law provides conscience protection for healthcare providers, facilities, and insurers. This means doctors, nurses, pharmacists, hospitals, insurance companies, anyone involved in healthcare delivery can refuse to participate in or pay for medical services that conflict with their personal, moral, or religious beliefs. They're protected from discrimination or legal repercussions for these refusals. So, if a doctor refuses to provide care based on conscience grounds, they can't be sued. They can't be disciplined by medical boards, can't face professional consequences. The law shields them completely. The scope is broad. It covers refusal for services like reproductive health and gender-affirming care. This is where the law's proponents say it's needed the most to protect providers who object to abortion or transgender treatments, which I personally agree that neither one of those things should exist. And there's legitimate debate about whether doctors should be forced to perform abortions or provide transition related care if they have moral objections. But the law doesn't stop there. The language is vague. It's vague enough that it can be interpreted to cover almost any medical service that a provider claims violates their beliefs. Prenatal care for unmarried women, treatment for people in same-sex relationships, care for anyone whose lifestyle the provider disapproves of. The law provides cover for all of it. There are exceptions. The law doesn't apply in emergencies. If someone comes into the emergency room needing immediate care, the doctor can't refuse based on conscience. The law also doesn't apply when a provider is contractually obligated to provide care. If you've agreed to provide certain services, you can't then refuse based on your conscience. But notice what's missing. There's no requirement that the provider refer the patient to someone who will provide the care. There's no obligation to ensure the patient receives the necessary treatment elsewhere. There's no protection for the patient who's being denied. The entire focus is on protecting the provider's right to refuse, with no corresponding concern for the patient's right to receive care. This creates situations where patients are left scrambling to find care. The pregnant woman denied prenatal care has to find another doctor, assuming there is another doctor available and willing to treat her. She has to explain her situation, face the potential judgment again, waste time that can be critical in pregnancy. And if she lives in a rural area where there aren't many providers, she might have to travel significant distances or even leave the state. The law was sold as protecting healthcare workers from moral dilemmas. The argument was that doctors shouldn't be forced to perform abortions if they believe abortion is murder. Nurses shouldn't have to assist in procedures they find morally wrong. Pharmacists shouldn't have to dispense medications they believe are immoral. And there's merit to some of that. I don't think that doctors should be forced to perform elective abortions if they have moral objections. I don't think pharmacists should be forced to dispense abortion pills if they believe life begins at conception. There's room for conscience protections in specific, clearly defined circumstances. But this law goes far beyond that. This law allows refusal of any medical service based on any moral or religious belief. It's not limited to abortion or controversial procedures. It covers basic medical care that should be provided to everyone, regardless of the provider's opinion of their lifestyle. The proponents of the law claim it's about religious freedom. They say that forcing Christian doctors to provide care they find immoral violates the First Amendment. They say that healthcare workers shouldn't have to choose between their faith and their careers. But this argument fails on multiple levels. First, providing medical care to someone is not an endorsement of their lifestyle. A doctor treating an unmarried pregnant woman is not endorsing premarital sex. The doctor is providing medical care to a patient who needs it. There's no violation of religious belief in treating someone whose choices you disagree with. Second, if your religious beliefs prevent you from providing basic medical care to all patients, you shouldn't be a doctor. Medicine is a profession with obligations. One of those obligations is treating patients without discrimination. If you can't do that because of your beliefs, find a different profession. Third, this creates a hierarchy of patients where some are worthy of care and others aren't, based on the provider's moral judgments. This is the opposite of what medicine should be. Medical care should be provided based on medical need, not on whether the patient meets the provider's standards of moral behavior. Now, let's talk about what this law is actually doing to real people, because it's not theoretical. This law has already been cited in cases of denied care, and the impact on patients has been significant and harmful. The case that brought this to national attention involved a pregnant woman that was denied prenatal care because she was unmarried. She was early in her pregnancy, a time when establishing prenatal care is crucial. She needed basic medical services, monitoring, testing, guidance about nutrition, and health during pregnancy. And her doctor refused. Not because of medical reasons, not because the doctor wasn't qualified to provide prenatal care, but because the woman was unmarried, and the doctor's religious beliefs led him to view her pregnancy as the result of sin that he didn't want to participate in facilitating. Think about what that means. A pregnant woman carrying a child who needs medical monitoring to ensure healthy development is denied care because the doctor disapproves of her marital status. The unborn child is being put at risk because the doctor wants to make a moral point. If you're pro-life, if you believe that unborn children deserve protection, this should infuriate you. The doctor's refusal to provide prenatal care potentially harms an unborn child. The justification that the woman shouldn't have gotten pregnant while unmarried doesn't change the fact that there's now a child who needs medical care, and that child's care is being denied. This woman had to find another provider. She had to explain her situation, face potential judgment again, delaying the care that she needed. The stress of this during pregnancy, it's harmful. The delay in establishing prenatal care could have negative health consequences, all because a doctor decided his moral judgment was more important than his medical responsibilities. And this ain't an isolated case. Since the law passed, multiple instances have been reported of patients being denied care based on providers' moral or religious objections. Not just prenatal care, not just reproductive health, various types of care are being refused because the provider disapproves of something about the patient's lives. Alphabet soup patients report being denied care. People in same-sex relationships seeking fertility treatments, transgender individuals seeking routine medical care unrelated to transitioning. We all know how I feel about those things personally, but they're human beings, and no human being should go without medical care. There's something horribly wrong with that. The law is being used as blanket permission to discriminate against anyone whose lifestyle offends the provider's religious sensibilities. Women seeking routine gynecological care have been questioned about their sexual history and denied care based on the provider's moral judgment of that history. Even those OnlyFans hoes need basic care. Come on now. Patients seeking contraception have been refused. Not abortifacients that some people believe end pregnancy, but routine birth control that prevents conception or regulates a woman's cycle. The impact falls hardest on vulnerable populations. People in rural areas with limited healthcare options can't just go to another provider if they're denied. Poor people without transportation can't travel to find care. People with limited insurance options can't switch to providers who will treat them. The law creates a two-tier system. If you're married, straight, living a lifestyle that aligns with conservative Christian values, you can get care anywhere. But if you're unmarried, LGBTQ, or otherwise outside the approved moral framework, you face barriers to accessing basic health care. And here's what's particularly galling. The doctors refusing care are often operating in communities where they're the only provider or one of the very few providers. They're not just refusing and allowing patients to easily go elsewhere. They're refusing while knowing the patient has limited alternatives, effectively trapping people without care. Consider a rape victim who becomes pregnant. She didn't do anything wrong. She's a victim of a violent crime. She needs prenatal care to ensure her health and the health of the child she's now carrying. And under this law, a doctor could refuse to provide that care based on personal beliefs about pregnancy outside of marriage or about how the victim should respond to the pregnancy. That's obscene. That's unconscionable. That's a doctor putting ideology ahead of a crime victim's medical needs. And the law protects that doctor from any consequence for that choice. The defenders of the law say that emergency care is still required, but pregnancy isn't treated as an emergency until something goes wrong. Routine prenatal care, which is essential for preventing emergencies, can be denied. By the time the situation becomes an emergency, damage may already be done that proper prenatal care would have prevented. The law also allows insurance companies to refuse to cover services they object to. So even if you find a provider willing to treat you, your insurance might refuse to pay based on their moral objections. This means that patients are hit twice. First with the denial of care, then with the denial of coverage if they manage to find the care. This creates situations where patients are forced to travel out of state to receive care. They're spending money they don't often have, taking time off work they can't afford to miss, dealing with stress and complications that could have been avoided if they could just receive normal medical care in their home state. The psychological impact is significant too. Being told by your doctor that you're morally unworthy of care is traumatizing. It creates shame and stigma around seeking medical help. It makes patients reluctant to seek care in the future because they fear judgment and rejection. This is especially harmful for people already facing discrimination. Alphabet soup individuals already face barriers to healthcare in the first place. Many report negative experiences with providers. This law institutionalizes that discrimination and makes it legal for providers to turn them away. Let's talk about the Hippocratic Oath and medical ethics, because this MEDA law contradicts the ethical obligations that doctors are supposed to uphold. The Hippocratic Oath, in its modern form, includes several key principles. First, do no harm. Second, treat patients with respect for their dignity and autonomy. Third, maintain patient confidentiality. Fourth, practice medicine competently and honestly. And critically, provide care based on medical need, not on personal judgment of the patient's worthiness. Denying necessary medical care to a patient based on moral disapproval of their lifestyle violates multiple aspects of this oath. It does harm by withholding needed care. It fails to respect patient dignity by making moral judgments about their personal lives. It prioritizes the doctor's beliefs over the patient's medical needs. The American Medical Association's Code of Medical Ethics is clear on this point. Physicians have an obligation to provide care to all patients regardless of personal characteristics or the social acceptability of their condition. While physicians can decline to take on new patients except in emergencies, once a physician-patient relationship is established, the physician has obligations to that patient. Refusing to provide prenatal care to a patient you've already established a relationship with because you disapprove of their marital status is abandonment. It's a breach of the physician's ethical duties. Under normal circumstances, a doctor who did this could face professional discipline, but Tennessee's law specifically shields doctors from those consequences. Medical ethics recognizes that doctors will sometimes face situations that conflict with their personal beliefs. The ethical way to handle this is to refer the patient to another provider who can meet their needs. The physician who objects to providing certain care maintains their conscience while ensuring the patient receives the necessary treatment. But Tennessee's law doesn't require referral. It allows doctors to simply refuse and leave the patient to figure it out on their own. This abandons the patient in their time of medical need. This isn't an ethical practice, no matter how you frame it. The fundamental principle of medical ethics is that treatment decisions should be based on medical need and best medical practices, not on moral judgment of the patient. A doctor who refuses to treat a lung cancer patient because they smoked would be considered unethical. A doctor who refuses to treat an injury sustained during risky behavior would face professional consequences. Why should refusing prenatal care to an unmarried woman be any different? The argument that providing care endorses the patient's behavior is false. Doctors provide care to criminals all the time without endorsing their crimes. Doctors treat self-inflicted injuries without endorsing the behavior that caused them. Providing medical care is not moral endorsement, it's fulfilling professional obligations. There's also the question of who gets to decide what moral or religious beliefs justify refusal. The law is vague on that point. Does a doctor who personally believes in prosperity gospel get to refuse care to poor patients because he views poverty as evidence of moral failing? Does a doctor with unusual religious views get to refuse care based on idiosyncratic beliefs? The lack of clear standards means that any claimed moral or religious objection is potentially valid grounds for refusal. This opens the door to all kinds of discrimination disguised as conscience protection. A racist doctor could potentially refuse to treat patients of certain races if they claim religious justification. The law provides no meaningful limits. Medical licensing is a privilege granted by the state in exchange for meeting certain obligations. One of those obligations is providing competent care to patients without discrimination. If you can't meet that obligation because of personal beliefs, you shouldn't be licensed. It's as simple as that. The state's not obligated to grant you a medical license while allowing you to pick and choose which patients you'll treat based on your moral opinions. The conscience rights of healthcare providers need to be balanced against patients' rights to receive care. Tennessee's law completely disregards the patient side of that balance. It's all about protecting providers, with no corresponding protections for patients who are harmed by refusals of care. Other states that have conscience clause laws include safeguards that Tennessee's lacks. Requirements for referral, requirements for emergency care defined more broadly, anti-discrimination provisions that protect patients. Tennessee's law has none of this. It's completely one-sided protection for providers at patients' expense. Now, let me explain why conservatives in particular should be leading the opposition to this law. Because this ain't a conservative law. This is big government enabling discrimination. That's got Democrats written all over it. And that should be an anathema to conservative principles. First, conservatives believe in limited government. We believe that the government should not insert itself into private transactions and relationships unless it's absolutely necessary. But this law does exactly that. It empowers government to protect certain people's right to discriminate while doing nothing to protect others from that discrimination. A truly conservative approach would be to get the government out of healthcare decisions entirely and let the market work. If a doctor doesn't want to treat certain patients, they'll lose business. If enough doctors discriminate, there's an economic opportunity for doctors who won't discriminate. The market naturally punishes discrimination without needing government protection for discriminators. Second, Conservatives believe in personal responsibility. If you choose to become a doctor, you accept the responsibilities that come with that profession. One of those responsibilities is treating patients without discrimination. If you can't fulfill that responsibility because of personal beliefs, that's your problem to solve, not something government should protect you from facing consequences for. Third, conservatives believe in protecting the vulnerable. An unborn child whose mother is being denied prenatal care is vulnerable. That child's health is at risk because of the doctor's moral judgment of the mother. Pro-life conservatives especially should be outraged that unborn children are being put at risk by this law. Fourth, conservatives believe in equal treatment under the law. This law creates different treatment for patients based on the provider's subjective moral judgments. Some patients can access care easily, while others face barriers. This is the opposite of equal treatment. It's government-sanctioned discrimination. Fifth, conservatives oppose government picking winners and losers. But this law picks winners. It protects healthcare providers from market consequences of their discrimination and losers, patients who are denied care. If providers want to discriminate, they should face the market consequences. Government shouldn't shield them. Sixth, conservatives believe in property rights and freedom of association. But medical licenses are government-granted privileges, not property rights. And once you accept a patient, you've entered into a professional relationship with obligations. This isn't about freedom of association. This is about government protecting people from the consequences of abandoning professional responsibilities. Seventh, conservatives value life and protecting children. A law that allows doctors to deny prenatal care to pregnant women puts unborn children at risk. That's not pro-life. That's allowing moral posturing to override health needs of innocent children. Conservatives should be furious about this. The religious freedom argument doesn't hold up to scrutiny either. Religious freedoms means government cannot force you to violate your religious beliefs. It doesn't mean government must protect you from all consequences of acting on those beliefs. If your religious beliefs prevent you from fulfilling professional obligations, the answer is to choose a different profession, not to demand government protection for discrimination. And let's be clear about what's being protected here. A doctor's decision to deny care to an unmarried pregnant woman is not based on any serious theological position. There's no Christian doctrine that says doctors should refuse to treat people who've sinned. Jesus healed without judging. He dined with sinners. He showed compassion to the marginalized. The doctor refusing care to an unmarried pregnant woman is not following Christian principles. He's using Christianity as an excuse for discrimination, and conservatives should not be defending this. We should be calling it out as perversion of religious values to justify treating people poorly. There's also the slippery slope to consider. If government can protect doctors who discriminate based on moral beliefs, where does it stop? Can a doctor refuse to treat a patient who's divorced? Can they refuse care to someone who's had an abortion in the past? Can they refuse treatment to someone who uses contraception? The principle being established is that providers' moral judgments can override patients' medical needs. conservatives should recognize that this principle can be turned against us. What happens when progressive doctors start refusing to treat conservative patients based on moral objections to our political views? This law is bad policy that conservatives should oppose on principle. It's government overreach. It's protection for discrimination. It's putting ideology over professional responsibility. It's harming vulnerable people, including unborn children. Every one of these points should make conservatives uncomfortable with this law. So, what needs to be done? How can we fix this bad law and protect patients while still respecting legitimate conscience concerns of healthcare providers? First and most importantly, the Tennessee legislature needs to amend this law immediately. Add protections for patients. Require that providers who refuse care based on conscience must refer patients to providers who will provide care. Require that refusal cannot occur in ways that harm patient health or abandon a patient's mid-treatment. Narrow the scope of the law. Conscience protections should apply to specific controversial procedures like abortion or assisted suicide. They should not apply to routine medical care like prenatal treatment. There's no legitimate conscience objection to providing prenatal care to an unmarried woman. The law should not protect that kind of discrimination. Include an anti-discrimination provision. Make clear that the law cannot be used to discriminate based on race, sexual orientation, marital status, or other protected characteristics. Ensure that patients have recourse if they believe they've been discriminated against under the guise of conscience protection. Require that hospitals and healthcare facilities that employ providers using these conscience clause ensure that patients can still receive care. If one doctor refuses, the facility must have other providers available. Patients should not be turned away entirely because of one provider's objections. Make the emergency exception broader. Don't wait until the situation becomes life-threatening to require care. If denying care could lead to health complications, it should be considered an emergency situation where conscience refusal is not permitted. The medical licensing boards need to establish clear ethical guidelines. Make explicit that patient abandonment, even under this law, is grounds for professional discipline. Clarify that the law protects refusal to perform certain procedures, not refusal to treat certain types of patients. Professional medical organizations need to speak out. The Tennessee Medical Association should make clear that denying prenatal care to unmarried women is not acceptable medical practice. They should establish standards that their members are expected to follow regardless of what the law technically permits. Insurance requirements need to change. If a provider is going to refuse services based on conscience, that should be disclosed up front. Patients should know before establishing a relationship with that provider what services they won't provide. And insurance panels should ensure that patients have access to providers who will meet all their healthcare needs. Patients who are denied care need legal recourse. Even if the provider is shielded from discrimination claims, there should be mechanisms for patients to file complaints and seek remedies when they're harmed by refusals of care. The current law provides no protection for patients at all. Conservatives need to lead on this. We need to make clear that this law does not represent conservative values. that we support religious freedom, but not discrimination disguised as conscience. That we believe in personal responsibility, which includes fulfilling professional obligations. That we protect the vulnerable, including unborn children whose health is jeopardized when pregnant women are denied care. We need to primary any Tennessee legislator who voted for this law and refuses to fix it. Make this an electoral issue. Show that there are political consequences for passing laws that allow discrimination and harm to vulnerable people. We need to support organizations fighting this law. Legal foundations challenging the law in court. Patient advocacy groups helping people that are denied care. Medical ethicists speaking out against the law. Give them the resources and support they need to fight effectively. And individuals need to act. If you're in Tennessee, contact your representatives. Make clear that you oppose this law and want it changed. If you're a healthcare provider troubled by the law, speak out publicly about why it's wrong. If you're a patient affected by this law, tell your story. We also need to be careful about how we discuss conscience rights. They're important. There are legitimate situations where healthcare workers should not be forced to participate in procedures they find morally wrong. But that needs to be balanced against patients' rights to receive care. Tennessee got that balance completely wrong. The goal should be a system where providers can maintain their conscience while patients still receive necessary care. That requires thoughtful policy that considers both sides. Tennessee's law only considers one side. That's why it needs to be fixed. The Tennessee Medical Ethics Defense Act is bad law that needs to be changed. It allows healthcare providers to deny necessary medical care based on moral judgment of patients' personal lives. It provides zero protection for patients who are harmed by these refusals. It contradicts basic medical ethics, and it violates conservative principles. A pregnant woman in Tennessee was denied prenatal care because she wasn't married. An unborn child was put at risk because a doctor wanted to make a moral point. I personally wouldn't have even known about this thing getting passed if it wasn't for one of my followers on TikTok that sent me a video about this. This is not acceptable. It's not Christian. This is not conservative. This is discrimination enabled by government, and we should all oppose it. I don't give a damn what side you're on. If you believe in religious freedom, you should oppose this law because it perverts religious freedom into license to discriminate. If you're pro-life, you should oppose this law because it puts unborn children at risk. If you're a conservative, you should oppose this law because it's government overreach that picks winners and losers. The law needs to be amended to include patient protections, referral requirements, narrower scope, and anti-discrimination provisions. Healthcare providers need to understand that medical ethics require treating patients based on medical need, not moral judgment. And conservatives need to lead the fight to fix this law rather than defending it. We can protect conscience rights while also protecting patient access to care. It's not an either-or situation, but Tennessee chose to protect only one side. And that choice is resulting in real harm to real people. When you take the Hippocratic Oath, when you accept the privilege of a medical license, you accept responsibilities. One of those responsibilities is treating patients without discrimination. If you can't do that because of personal beliefs, that's your choice. But you shouldn't be a doctor, and the government shouldn't protect you from the consequences of failing to meet professional obligations. Providing medical care to someone is not endorsing their lifestyle. It's fulfilling your professional duty. A doctor who treats an unmarried pregnant woman is not endorsing premarital sex. The doctor is ensuring the health of a patient and an unborn child. There's no violation of religious principle in doing that. The Tennessee legislature passed this law quietly, hoping it wouldn't get much attention. Now that people understand what it does and how it's being used, there needs to be public pressure to fix it. This shouldn't be a partisan issue. This should unite anyone who believes in basic fairness and medical ethics. But all you people want to do right now is fight about ICE. Conservatives have an opportunity to show that our principles mean something, that we don't just support religious freedom when it's convenient, that we actually care about protecting the vulnerable and ensuring equal treatment, that we oppose government-enabled discrimination even when the victims might not be our usual constituency. The woman denied prenatal care deserved better. The unborn child deserved better. Future patients who will face similar discrimination deserve better. Tennessee can do better, and conservatives should demand that it does. This law is wrong. It needs to be fixed, and anyone who cares about medical ethics, religious freedom, properly understood, conservative principles, or basic human decency should be demanding that Tennessee fix it immediately. The Hippocratic Oath says, first, do no harm. Denying necessary medical care to a pregnant woman does harm to her and to her unborn child. No amount of moral posturing changes that. No invocation of religious freedom justifies it, and no law should protect it. Tennessee, fix your law. Protect patients. Ensure that health care is provided based on medical need, not moral judgment. And conservatives, hold Tennessee accountable for doing so. This is a test of whether our principles mean anything, or whether we'll defend anything as long as it claims to be about religious freedom. Choose rightly, fix the law, protect patients, and ensure that medical care is available to all who need it, regardless of a provider's moral opinion of their personal lives. That's what medical ethics require. That's what conservative principles demand, and that's what Tennessee needs to do.